Honorable Lonzi.
Oh, thank you, Chair. I won't be long. I did miss the intro. My name is Sihle Lonzi, from the Economic Freedom Fighters, as you can see. Thank you, Chair, and sorry for abusing the platform.
No, his name is Honorable Lonzi, a member of the committee, not from the
No, Chair, I've got one question. Hopefully, it's very straightforward. How many cases have you discovered of ghost students? So students who are either dead, students who are not studying, as you have said in some of the TVETs or CJs, because I know you made specific reference to CJC, but I'm sure you've got, you've been a national overview as well. How many do you have, and how much does that total to? And the reason I'm asking this, I think it may have been insinuated by one of the members. You know, it's good that you are doing a good job in recovering the money and giving it back to NSFAS, and I think we must commend you for that. And your proposals in having an NSFAS account that will also deal with the interest aspect of it. But there's also a social cost to this, because if, for example, I know you mentioned here, take Wits University. You take 400 million back from Wits University to give back to NSFAS. All good and well, we're happy, we've recovered 400 million. But that means there are 400 million worth of students who were supposed to receive funding from NSFAS. Those students have dropped out, they've gone back home, they are sleeping outside. So there's a social cost and interest that must also be considered. And I know this may not necessarily be in your mandate, but I wonder, as part of your reports, if it's something that you can consider, or if it's something that you do to say, as a result of these institutions, public institutions, and even the scheme itself, paying people that don't exist, it means that X number of students were affected by this criminality, and as a result, society has lost out, on impacting the lives of these young people and how they are able to contribute into the economy. So you're doing a good job in terms of recovering, but that's the financial aspect. But there's also a social and societal aspect that I think we don't speak enough about. So I think those are my questions. How many, what is the round amount? And maybe give me your comments on the social cost of what does it mean when WITS gives you back 400 million when there are students who are supposed to be funded by WITS University. Thank you.
Honorable Ash.
Thank you, Chairperson. I would just like to know from the SIU, would you have loved for the Act to empower you to prosecute and do criminal litigation? Thank you, Chair.
Thank you very much, Honorable Msaza.
No, thanks, Chair. Maybe, Chair, I must admit that this language of the oppressor is not mine, so maybe my understanding is not doing justice. Chair, I want to take the SIU back to that point that I raised regarding the leasing of student accommodation. The statement, as I read it, it's clear to me to say that the finding of various service providers was that it contravened the university's SCM policies and Section 217 of the Constitution. So the irregularity is for various service providers. But then the SIU only points out at one service provider. So it cannot be that the finding speaks to various service providers, but the finding is for one service provider. And further to that, the SIU must then admit that there is an omission here, or this statement is misleading to some degree. I want to be taken to confidence with regards to this particular finding to say, what does it then mean? Because otherwise it should have been clear to say that out of the findings, we've so far found out that there was one irregular regular appointment of a service provider, whatever the case may be, but then we're still looking into other service providers that might be also implicated in this process. Thank you very much, Chair.
Thank you, Honorable Ngubane.
Chair, from my side, I'm not going to have too much follow-up. I'm happy that the response was to say they will look at the act of how to close the loophole, the gaps that are there to make sure that we don't just do the things for the sake of doing them. It's a lot of money. So if you can look at that and collaboration as well with the institutions within the justice system, that we follow up as if that has been responded to, I think I'm comfortable, Chair, with that. I'm okay. There's no more question.
No, Chair, I'll avoid having the alarm to ring before I finish. Mine is just simple, Chair, straightforward. I just want to check in terms of their observation. The issue of reconciliation, the problem that you have picked up, was it before or after the appointment of the administrator in terms of your reconciliation? But secondly, at some time in December, NSFAS appeared before us and told us of some disbursement unit there, or a disbursement manager. Can we get clarity in terms of whether are you aware of such, and in your own observation, is it yielding results? Because the expectation is that the problem of reconciliation should be dealt with as much as they've appointed or they've established a unit on disbursement. But the last part that I wanted to probably make it clear is the issue of reconciliation and your recommendations in terms of probably getting a consultant. I'm not sure if I heard you correctly as to whether you have recommended that there should be a consultant that deals with reconciliation, or it is NSFAS that has made a commitment that they will appoint someone. We should be clear in terms of our approach to this outsourcing of responsibilities. To a large extent, it speaks much on what we want to achieve as a developmental state. So with the two issues, those are the only two things but we vehemently oppose the outsourcing of such responsibilities, especially when we have that capacity internal. Thank you very much.
Thank you, Honorable Masak.
Thank you, Chair. I don't have, it's just one question. I just want to find out, in your investigation so far, is there, because like in the construction mafia, it's across the country, and here we have identified, like my honorable member has mentioned, that it's a very, very unholy ground when coming to higher learning centers or the tertiary institutions. Is there a person or persons of interest that you see the modus operandi in different higher institutions connected to the way of doing things when coming to where you identify corruption, or a company or companies that are connecting the dots within different higher education institutions? Thank you, Chair.
Honorable van der Walt.
Chair, I'll have a lot of questions in writing, preferably, but obviously, if TVETs is so bad in running finances, surely there must be another way to appoint or attract properly qualified, experienced CAs or CFAs or whatever the case may be. And with that, Chair, I actually question how we appoint people to work with millions and billions. I have a simple other question, and that's on slide 37. I'm not sure if I'm reading it right or wrong, but under civil litigation, there's a thing about supply chain management, If it can just come up in the second line, we say it's set down for a hearing on 18 to 20 March 2024. I see it's correctly there. I will still say 24 instead of 5. Thank you, Chair.
All right, SIU. You'll just answer all of them.
Thank you, Chair. In relation to the CJC investigation and whether we have picked up any ghost students, so how we define a ghost student is that you would find that they say Lucas is a student at a certain institution, and Lucas as a person does not exist at all. That's how we define a ghost student. What happened in terms of the CJC was that you'd find that a student would come in at year 1, and unfortunately during year 1 that student would pass away. But the institution would continue to claim for the student in year 2 and year 3. So in year 2 and year 3, that student would be seen as a ghost student, because remember in year 1 they would have passed away. What should have happened in the system was immediately when that happens, the institution should have let NSFAS know to say that from the cohort of students, unfortunately there's 1 or 2 that has passed away, so that NSFAS stops disbursing funds for those students. So in the case of CJC, when those students passed away or they left, they continue to claim. Because immediately when we come to CJC and we're looking for that student is not there. That student is a ghost. But you might find that one, they've passed away, or they've gone to another institution. But the funds that keep coming, they keep coming to the institution that submitted the initial registration. Because in the life of a student, you'd find that the student says, no, I'm going to study, is from Limpopo, I'm going to study in KZN. That's where they found space. But they realize that they don't want to be far from home. But remember that institution in KZN would have submitted that student that they are claiming for them. The student would then move to a separate institution. But what would happen is then NSFAS would keep paying from the old to the old institution. And sometimes they would pay both sides. They would pay to the old institution and they would pay to the new institution. But when we go investigate, we can't pick up this student at the old institution. Sometimes, like I said, they've actually passed away, but sometimes they've changed. That's where they would then say they are ghosts. But we haven't found instances where there is a person that never existed that was in the system. So we agree on the social impact for the students, because remember the whole point of the scheme is to assist struggling students who can't afford higher education. But if you take a student that is struggling to afford higher education and you put them in the system, but you do not ensure that by the time they finish their degree at year 3 or year 4, they do actually have the qualification to be able to look for work, it does not address part of the social consideration that we wanted to do, to say that we are empowering you so that you can assist yourself and you can assist your family. Because the fact that you're already under 350,000, that is the requirement, it shows kind of like the background that you're coming from. So that's why we're saying that we agree with Chair that the closeout is very important, because what it will allow NSFAS to do and the institution to do is to reconcile for those old students between 2017 and 2021, so they can actually get their qualifications and they can go out and look for work. And the other part of the scheme is also to ensure that we have a skilled labor force that can make us very competitive. But now you have students that have acquired the knowledge, but they can't do their practical lessons because you have not settled the debt with the institution. So we are very aware of the social impact that NSFAS has. That's why we have prioritized that part of the closeout. Some institutions are very welcoming, because they say now SIU is now in as part of the investigation. We are willing to say the students that we can give them their qualification, because we know there's an external party looking to make sure that we do get the money at the end of the day. But others are still very much on the hard line to say until there is the account are settled, we cannot remove, we cannot give the qualification. So we are very much aware of that. So in terms of the disbursement unit, yes, they have indicated to us that they are going to start a disbursement unit to specifically look at the reconciliation part. But how we work is we want to see the evidence first. So we said, look, either give us the recruitment plan and a plan of what the unit is going to do. And then we can then say this recommendation is taken care of by the disbursement unit. But until we can see that there is a recruitment plan, one, who's going to be sitting in that unit, what that unit is going to do, from our side, we still see it as a recommendation that has still not yet been implemented. So yes, they did indicate that they want to start the disbursement unit. The administrator that's currently there, he came afterwards. I think he came sometime last year, in April last year. The matters that we are dealing with are from 2017. They started in 2017, and then they're still carrying on. What created the problem mostly was, remember, there was the transition from the loan to bursary scheme. And then on top of that, they were also trying to move from manual applications to system-based applications. So what the model that they had built was not enough to deal with the volume that of increase when immediately when you say, okay, it's free education, so you receive more applications. But then your system should be geared for the additional applications that you're going to receive. But the system was not geared for that. That's when you had students that applied. They either said apply manually again, and then they were never captured. So that then snowballed into the different years when they didn't reconcile. But it's not all on the current administrator. He came and then he found the closeout project as part of the recommendations that was there to say we need to reconcile the prior years. I think is the one that I've missed. No, that one I will give to Advocate Vanara or to the COO.
All right, and thanks, Honorable Chair. I think just to come closer to assisting the Honorable Member to understand, I'll just tell you, when we do the investigation, there are three focus areas. Let's say we're looking at 4 leasing companies. First, we look at procurement process followed. Secondly, we look at the value for money. We look at the payments and there's value for money. And 3, we look if there's any collusion between the two. Now, what you read in that paragraph, it says we've identified several service providers, which we all found to have been appointed irregular. That deals with the procurement process. So all 4, we've done with that. Second fight is now we look at the payments and check whether there's value for money. Where we go and check whether have they been paid according to the contract, are they providing the service they're being paid for. That's another process. Now, the reason why you do not find the other 2 from the 4 is because for now we've already, remember, once we do that, we take those matters to civil litigation for us to recover whatever amount. There's a quantification process. You set aside the contract and then you quantify how much can you recover out of that money. So as I said earlier on, you will find that there was a low-hanging fruit where one service provider immediately said, yes, I agree, this was an overpayment, and we deal with them, we put them aside. The other one is the one of the 64 million, of the 68 million, which was above the 8.7 million. That one, as I said in the statement, we are referring it to our civil litigation to see, because some of them, they may not give you the AOD. You have to go and fight them in the special tribunal to get the money back. Now, the other 2 that you don't see there is because the investigation is still, the quantification is still ongoing. So once we're done with that, they will also be part of the report. So there is no misleading of any information, such that there is a processes that we've got to be following. I hope I've clarified better now. Thanks. Chair.
Chair, with your permission, the issue of the consultants, I see that I didn't clarify that matter. When we started the investigation, we found that NSFAS had hired consultants to assist with the closeout project of reconciliation. But what was concerning was that there was no plan to insource that function. And then we said that is concerning because the reconciliation of all these monies should happen every academic year. So it's creating the impression that every academic year you're going to have these consultants coming in to do the work. And then we said, no, you need to give us a plan of how you're going to insource the reconciliation process, because it's a critical part of your business. Consultants can come in to assist, but the knowledge base and the hard work of the reconciliation should sit internally with NSFAS. And I think that's where that disbursement unit is trying to come in to address that recommendation of the SIU in relation to the reconciliations. Thank you, Chair.
Thank you, Chair. To add on to the issue of social impact, this is one of the things that we normally do. I think once we're done with the investigation, we're able to indicate what happened and what should have happened and what is the impact. I can indicate that in terms of the build and the water sector, we always go back and say the lack of services, what has it done to the community, so that we can able to address those issues and they can come out clearly that the fact that procurement process didn't happen is a result of it. What impact did it had on the community? We have done such investigation on the water sector, where water was supposed to have been given to the people and it was not given, and it has caused a lot of impact. So we do take that into cognizance. And on the issue of the bursary, I think once we're done with the investigation, we'll be able to see what impact it has made in terms of that. Then on the issue whether there's a person of interest across for now, in terms of the Department of Education and Training, these are isolated incident, and these are the issue pertaining to different students. So it's a totally different type of scenario where we normally investigate into. But some of this procurement, the people that are involved here, we look into the entire database of where we are, whether do we pick them up anywhere else. But mostly here you can see that it's student and it's the disbursement and all those things. It's less procurement that is involved here, but we haven't found them in other sectors or in other procurement, but we are constantly looking in order to see whether are these people involved anywhere else, so that we can able to take action on them. Thank you.